So the certified true copy of the judgment of the court on Senator Natasha is out. It's long awaited. Lots of Nigerian citizens were waiting for it. You could observe that ever since the judgment was given, I personally refused to make an analysis on it because I wanted to see the certified true copy of the judgment to be able to know exactly what is inside. So we now have the certified true copy, and we have to look at it one after the other. We look at the orders of the court. What did the court say about Senator Natasha's case? We look at it one after the other. So this is the enrolled order of the court, right? This is the enrolled order of the court. You can see it here in the Federal High Court of Nigeria, in the Abuja Judicial Division, holding at Abuja, Friday, 4th day of July 2025, before His Lordship Honorable Justice Binta Motala Nyako. You can see the suit number there. So the suit was between Senator Natasha Akpotu-Uduaghan and the Clerk of the National Assembly, the Senate of the Federal Republic of Nigeria, the President of the Senate, number 3. Number 4, the Chairman, Senate Committee on Ethics, Privileges, and Public Petitions, Senator Neda Imasaun. And this is what you see here, judgment order. Now let me explain this. When judgment is delivered by the court is expected to issue 2 documents. Number 1 will be the entire judgment, okay, the full judgment of the court. Even if the judgment was 200 pages, 300 pages, the court is expected to sign and give out to the parties and to the public the full text of the judgment. That's the first thing that is usually given. The second thing that is usually given is a summarized version of the judgment, usually called judgment order. So that is what you have here as judgment order. So this one goes straight to the point. It goes directly to the orders of the court. It goes directly to the decision of the court in a matter. It doesn't talk about the entirety of the story of the matter, but goes straight. Okay? So that is why you now have it, judgment order. And following the judgment order is the names of the counsel, the senior advocates that appeared in the matter. Plenty senior advocates, I must tell you. Okay, and this is the name of the judge that presided over the matter, Honorable Justice Binta Nyako. And this is her signature, so she has signed, and that makes it valid. All right, so we can talk about it. So let's look at what was said in the judgment of the court. What exactly did the court say? Okay, so we go straight. I will look at where the court made a clear statement. We come to order number 2. It says that having found that the plaintiff, Senator Natasha Akpotu-Uduaghan, acted in breach of this court subsisting order, the order that said don't make any comment, don't say anything because the matter is in court. Remember that Senator Natasha Akpotu-Uduaghan made the satirical publication on her Facebook page, and that is what the judge is saying here. It says that having found that the plaintiff, Senator Natasha Akpotu-Uduaghan, acted in breach of this court subsisting order, the plaintiff must take responsibility for her action and remedy same. Therefore, an order is hereby made for the plaintiff, Senator Natasha, to pay a fine in the sum of 5 million naira to the federal government treasury and to publish a public apology to the court in 2 national dailies and on her Facebook page within 7 days from today to purge herself of the contempt. So the simple implication of this is that 1, the court has convicted Senator Natasha Akpotu-Uduaghan of contempt of court, and for that reason the court has made order for her to pay 5 million naira to purge herself of the contempt, and the money is to be paid into the treasury of the federal government. The court also made an order that she should publish an apology to the court in 2 national dailies and also publish on her Facebook page to purge herself of the contempt. This is the strongest pronouncement of the court in this very order that we are seeing. Number 3, the judge simply said preliminary objection succeeds in part that some aspects of the case relating to fundamental rights can be taken at any time without necessarily waiting for the breach of fundamental rights to occur. When there is likelihood of breach of fundamental rights, you can go to court. So that's just an affirmation of the position of the law. You see number 4 here, order number 4, that the application for interlocutory injunction filed, which reliefs are similar to those in the originating summons, are subsumed into the originating summons. 5, that relief 2, 3, 4 calls for interpretation. 6, that a senator can only raise issues of privilege upon complying with the provision of Chapter 3, Order 6 of the Senate rules, that is standing by your seat as allocated to you. Number 7, right? Number 6. Okay, so number 7, that I also find that the Senate rules is superior to the Legislative House Powers and Privileges Act, okay, by virtue of Section 20 thereof. Just a general pronouncement about the observations that the court had. Number 8, this is important. Order 6 of the Senate rules gives the power to allocate and reallocate seats to the senators to the Senate President without conditions. This one simply says the Senate President has a power given by the applicable rules of the Senate to allocate seats to me, and tomorrow he decides to say, I don't want you to sit there again. I hereby allocate another seat to you, and that you cannot query it. It is the power of the Senate President so to do. 9, reliefs 4, 5 bordering on the actions of non-actions of the second and third respondents. I find that for as long as the Senator Natasha Akpotiuduaghan, was not speaking from the seat allocated to her, the Senate President cannot and should not take any steps in the plaintiff's matter, as the plaintiff has not complied with the Senate rules which govern her as well. Still basically saying that Senator Natasha Akpotiuduaghan ought to have moved from where she was to where she was allocated, and that it is the Senate President that has the power to allocate, and therefore when you don't speak from your seat, Senate President has the power not to give you a hearing. 10, that to suspend a member, and this is important, that to suspend a member for a period of 6 months equals to a suspension for 180 days, and that this is the same number of days a member is expected to sit in the House representing his people. That I find this excessive and overreaching, noting that it will prevent a member from complying with the provision of the Constitution regarding the number of days that a senator should sit. So the judge is basically saying that to suspend Senator Natasha Akpotiuduaghan for 6 months is excessive. That 6 months is 180 days. And that the Constitution of the Federal Republic of Nigeria in Section 63 says that a senator should sit for not less than 180 days in the plenary attending to legislative discussions. And therefore, the judge came to the conclusion here that 6 months is excessive. Now, the judge now said, and this should be noted, that I am of the opinion, note, that I am of the opinion that the Senate has the power to review the provisions of the Senate rules and can even amend Section 14 sub 2 of the Legislative Houses Powers and Privileges Act, both and for being excessive and overreaching. So this is a judge basically giving admonition to the Senate, suggesting to the Senate, because what is principle here is I am of the opinion. Okay, so this is an admonition to the Senate. It's no more an order. It is an admonition to the Senate to think of amending so as not to suspend the senator for a longer period of time. And finally, and this is very important, that the Senate has the power to, and I believe, note, Senate has the power to, and I, the judge, believe that the Senate should recall the plaintiff and allow her to resume representing the people who sent her there to represent them. So basically, there are few orders, though we have number 1, 2, up to 12, but very few direct and positive orders of the court to the Senate. Now, here is the implication. If this is not obeyed, let's just assume, if the Senate decides not to obey this, it will be difficult for Senator Natasha to have a particular point to go to court for contempt against any official of the Senate. Because most of the orders here are directory. They're just advising. They're not positive orders. To say the court the court hereby makes an order for this. The court makes an order for this. For us that are very close to activities in this ecosystem, court orders are usually positive. The court hereby orders that you should release this man from prison custody. The court hereby orders that you should pay this man 100 million naira. Those are positive orders of the court. If you look at the second order, okay, the orders of this court, the second order was positive, said you must pay 5 million naira, you must publish apology in 2 national dailies, you must also publish it on your Facebook page. With due respect, that is how orders of the court are: positive, straightforward, not mediatory in litigation, not suggesting what to do. It is, however, not wrong for the judge to suggest, okay, but suggesting doesn't make it a binding order. That is the danger of the court, and that is why it would have been preferable to make clear, positive order. Command. This is a court of law. You command the doing of a thing, and that will be complied with. Anybody that fails to comply with it, then the person can be charged to the court for contempt of court. But in this very one, it might be difficult to charge anybody for contempt of courts, from the leadership, in the leadership of the Senate. So this is the last page. It's usually signed by the registrar. So the registrar of the court has signed Kanu Ngozi B, and this is a certified true copy of the order of the court. So this is the much anticipated order of the Honorable Justice Binta Nyako. Nigerians were waiting for it. For me, it took too long for this order to come out. It should have come out the following day or even that same day. But finally, it has come out, and this is what the order is. Now, let's ask a few questions. Has the court ordered the Senate to, right? Has the court ordered for the senator's return to the Senate? That's the question. Has it ordered for the senator's return to the Senate and take her seat? Now, I honestly have not seen it in this order, and that is why I had to bring out the order as it is, in its raw form, so that you can also see it. I honestly have not seen where the court has ordered for the senator's return in this order, right? I don't know if you have seen it. If you have, point it out in the comment section so we look at it again together. But from where I stand, I have not seen any order of the court ordering for Senator Natasha's return to the Senate. Most of the orders are directory as against positive orders. They are advice, suggestions. I believe, I think so, I hereby suggest. That's what we have seen in most of the orders. And that makes it a difficult one for Senator Natasha. Senator Natasha went to court expecting that the court is going to rule, to make a positive order, to say, return to the Senate, your suspension is unlawful, or your suspension was for a very long period of time, so reduce your seat and all that. But I'm afraid Senator Natasha has not gotten that from these very orders of the courts that we have seen. So what can she do at this point? What can she do? Right? One, she can accept the decision, pay the money, publish the apology on national dailies and on her Facebook page. She can decide to do that and then return to the Senate. If that is done and the Senate refuses to take her back, the public outcry will be too much against the Senate. This woman has done all this and you are still saying she shouldn't come back. Nigerians will be saying all that. So she has an option. This is distinguished Senator Natasha, right? We all know her. She has the option of complying with order 2 of the decision of the court. Offer the apology, pay the money, 5 million naira. I mean, she has more than 5 million naira. That's a small money for her. She can pay. She can also, in fact, some friends can decide to pay that money for her so that she can return to the Senate. So that's the first thing that she can do. Number 2, she can go on appeal to challenge the orders of the court. She has the right of appeal. As a citizen of Nigeria, the judgment of the court is the final decision of that court. As of right, she can go to the Court of Appeal, Abuja, and challenge that decision and say, no, the trial judge was wrong in convicting me for contempt. Contempt is a criminal matter. I was not heard, was not given a fair hearing. I was not served with from this, from that. Lawyers would understand what I'm talking about. So I shouldn't have been convicted for contempt. It did not arise, and so on. So she can go to court to challenge the Court of Appeal, to challenge the judgment of the trial court, right? She can also challenge the award of 5 million naira, challenge the publication, and challenge any other thing she wants to challenge, and challenge the fact that she has not been returned to the Senate by the trial court. She can challenge anything that she wants to challenge from the judgment of the court. It is her right as a citizen of Nigeria. Note also that the Senate can also cross-appeal. The Senate has a right to appeal. The Senate can go to court and say, the 5 million naira was small, my lord. It should have been more than that. The apology in 2 national dailies was too small. It should have been more than that. Or any other aspect that they disagree with the trial court, they can do what is called cross-appeal. Cross-appeal is Natasha has filed an appeal. We also double-cross and put our own on top of her own, and then ask the court to hear it together. So 2 appeals, in one court against the same judgment. Now, the coming days will really, tell what's going to happen. If Senator Natasha has gone to the Court of Appeal, she's certainly going to publish it for us to see the grounds of appeal. It's a case that Nigerian citizens and even citizens from outside Nigeria are interested in knowing the outcome and knowing the way forward, knowing how it is going. And I can only say, as Nigerians, what's our own, we'll continue to watch and see what comes out of this matter. Many thanks for watching. Do remember to subscribe and share.